ladies and gentlemen. It's an absolute privilege and pleasure to be here before you. It's fantastic to see so many people that are interested in vacant property, and I would pay tribute to your hosts in that regard. I may be one of the few people in the room that actually, apart from your hosts, who actively welcomes an empty property at the present moment in time. I have a 3-year-old and a 1-year-old, but their primary focus in life seems to be to keep me up through the night. So I do apologise if I lapse into periods of hyperactivity or else extreme monotony. I'll try to avoid that as best I can. Anyway, I'm Bryan Johnston. I'm in the real estate litigation unit at Clifford Chance, a large law firm which operates globally. We come across lots and lots of different property issues, all the sort of things you would expect to see, but obviously we come across empty property from time to time. And empty property is a bit of an issue. It's a bit of a big issue. And it covers a number of different aspects. What essentially I'll try and cover in a very short space of time, I promise to try and keep to that time as well, are a number of key features of how empty properties dovetail into the law. Property management issues, rates and insurance, insolvency, multi-let property issues, and of course the thorny topic of trespass. Firstly, dealing with property management issues. Well, firstly, you might actually have a lease as a landlord, and the lease is tenanted. Well, obviously it's tenanted, but the tenant is no longer there. The tenant has vacated. They've done a runner. The lease is continuing. So what does that mean? Well, that means that there's potentially a breach of covenant. There's likely to be if your lease is properly drafted. That will give rise to the right to forfeit. But then the question that the landlord needs to make is it right and appropriate to forfeit that particular lease? It would be wise and certainly appropriate to assess the market first. Otherwise, of course, the landlord is going to risk getting back an empty property which the landlord is going to be responsible for. So it'll have to deal with security issues, insurance issues, rates, risks, but with no income stream coming in to protect them. There's also a risk of an implicit surrender in such circumstances. So landlord faced with an empty property, it thinks, oh gosh, I've got to go and secure this because there's no tenant there. There's a bit of a risk with doing that because what message that might send out legally is that the landlord has taken possession back and therefore is taking risk back. Tenancy is at an end. So landlord has to be very careful and wise to seek legal advice in such situations. So the landlord can also let the liabilities at the empty but continuing lease property accrue. But the question then has to be asked, can the tenant be found? Can it be traced? And obviously we can employ search agents to do that. Can the tenant actually then pay? Does it have any resources? Clearly, if the tenant is solvent, action can be commenced against it. If not, if the tenant's unsolvent, then unfortunately the landlord's going to rank unsecured against the tenant. In the insolvency. The cost of enforcement needs to be factored into the mix as well. It should be weighed up against the likelihood of recovery and the amount that is actually likely to be recovered. It may be preferable actually not to enforce, but to allow the lease itself to continue so that the landlord then doesn't become liable for the costs of recovering occupation. Finally, a landlord has other options. It can look to a tenant's guarantor, if there is one. If there's a rent deposit, it can look to draw down on the rent deposit. If there are subtenants of part, serve as Section 6 Law of Distress Amendment Act notice while you still can before the new Courts, Tribunals Enforcement Act regime comes into place. That can be served so to get the subtenancy rents coming up directly up into the landlord's account. Or are there any former tenants upon which you can serve notice and get the former tenant through contractual liability or indeed through Landlord-Tenant Companies Act 95 to pay the liabilities as they fall due? And obviously there's only a six-month window between the liability falling due and the ability to recover it. So serve notice fast if there is a former tenant to make sure you can recover from them. So let's just assume then that our lease has actually come to an end. For some immediate issues that do arise with that, assuming that the landlord has no real intention to refurbish or redevelop a property, the landlord's aim has to be to market and relet that property as soon as possible. What is the risk of not doing so? Well, it's the impact on the landlord's investment value, especially if it's contemplating a sale. The landlord itself may, of course, be a tenant of a superior landlord and will owe financial obligations upwards, so the income stream is not coming in to help the landlord satisfy its own obligations. In a similar vein, the landlord may well have its own mortgage or loans to facilitate. Further, there are also multi-let issues, and we'll come on to those later. Landlords clearly need to be proactive. They could need to consider when to market a property to narrow any window for any potential void period. Landlords should anticipate when a tenant might want to break, so active management of the break process. And indeed, it may well be worthwhile a landlord challenging a tenant break. A recent case, I think from 2 years ago now, Avacet, a condition to break was that the tenant had to pay all interest charges. Now, the landlord didn't need to serve notice or anything on the tenant of what the interest charges were. And I think the amount was £300 and something in a £70,000 per annum rent. And that was held, the Court of Appeal held that the non-payment of the £300 didn't satisfy the condition in the break clause, therefore the break was not effective, and therefore the lease continued. Therefore that tenant was left in the hole, but the landlord at least had a tenant in occupation, still liable to pay rents, etc., etc. That's the sly way of doing it, by the way. But courts have this rather annoying principle of equity, and there are other cases which tend to suggest that a court will try and find ways to help a tenant. A recent one involving Marks and Spencer's, where the court found an implied term which enabled an apportionment of rent paid after event, not quite on point, but relevant to break clauses. Anyway, communicating with the tenants is actually a novel idea, but it certainly works very well as well. Find out what their intentions are and try and work with them to help manage that process. Temporary lettings are also worth considering as well. If you are left with a property that's vacant, well, what can you do in the interim? Deal with waste issues, get the place tidied up. Has the tenant left its fixtures there? Deal with those. Deal with chattels. Remember, you might become an involuntary bailee for those chattels, so you have to actually look after the goods, allow the tenant appropriate time to get rid of them, remove them, etc., before you then sell them. And if you do sell them, then you have to account to the tenant for any proceeds after your costs of disposal, etc. Make sure there's nothing in the site which is actually going to go on fire or anything that might actually potentially flood the site. Never good. Perform any repairs in the period that you've got to do it. Pursue your tenant for dilapidations as well. Make sure, obviously, the property is secure. It'll be required by insurance and also protect against theft, vandalism. Security doesn't need to be barbed wire and horrible stuff like that. I'm sure many of you have seen in some shopping centres very aesthetic use of security, like beautifully printed screen hoardings where you don't actually know you're walking past a vacant unit. Deal with issues like electricity and water supply to the property. For example, is the tenant's contract still continuing in respect of those supplies? If so, well, the tenant may well be liable for it. If not, deemed liability of the person who's entitled to the occupation, namely the tenant's landlord, and that's likely to be on less favourable terms. So a decision will need to be taken there. So landlords clearly should be taking readings and just monitoring use. Decision, again, will need to be taken. Is it more beneficial to cut off the supply and potentially face the costs of reconnecting it for purposes of marketing, or as an incentive for an incoming tenant to make sure that they've got a supply which they don't have to pay for when entering into property, hopefully following a new letting. Now we move on to the rather thorny issue of rates. The Ratings Empty Properties Act 2007, as I'm sure you all know, removed various rate reliefs. So at present, there's empty property relief available for commercial properties at 100% for 3 months and industrial at 100% for 6 months. After that, that is it. The person in occupation of a property is liable for the rates. And it seems a bit strange, really, because rates are all about the occupation of property, yet they have significant effect on unoccupied property. And in a stagnant economy, I think we'll probably all agree that that's essentially what we've been in for quite a period of time. These are very short periods of relief indeed. So is it fair for a property owner desperate to attract a tenant to pick up the liability? Indeed, BPF, British Property Federation, have styled the current rate regime as a tax on business failure. There's probably an element of truth in that. I mean, originally when it was brought in, it was designed to encourage quick turnover of lettings to ensure that property was taken up, but we're in a very changed market since then. A creative solution to the problem would be to involving local authorities being flexible in respect of rates liabilities. If to relax the regime would genuinely encourage businesses to continue or new business to be attracted to local centres. If rates are an issue in a local area, then the risk is that that particular local area loses its critical mass of businesses and local enterprises, with a house of cards effect on other businesses in the area. Now, with recent legislative changes, conversion of commercial to residential property is a potential option to use vacant space, but it would seem sensible nonetheless to review the current law to protect town centres as business and commercial centres, and also to protect, of course, already struggling property owners. Ways of which you could do that, you could extend the rent-free period from 3 months to indefinite, would be wonderful, or potentially provide rate relief at, for example, say 50% after the 3-month period or extended period, as may apply. Now, there are some solutions to the rates problem. We have the short-term lease, or indeed a license perhaps of 6 weeks or more. I'm sure many of you have heard of pop-up shops that just appear for a short period of time and then go away again. That's a potential way to deal with it. BPS, meanwhile, use leases, all relevant. And indeed, in terms of this type of short-term letting or licensing, there's some helpful cases. We recently had the case of Macro against Nuneaton and Bedford Borough Council. And in that particular case, the tenant took space of 0.2% of a warehouse. And in that 0.2%, it stored some documents on some pallets. Not exactly an intensive use, I think we would all agree with that. Now, the court held that the criteria for satisfying rateable occupation and thus protecting a landlord from rates liability and then triggering a new exemption period at the end of the lease was satisfied. The High Court held that the tenant was an actual occupation, the occupation was beneficial to the occupier enjoyed exclusive use, and the occupation was not transient. And further, having considered the fact that was this a mechanism to avoid rates liability, which the court did consider, it said that didn't matter, and held that the property was being occupied for rateable purposes. That decision, again, has been considered in Cheshire and West Cheshire against Public Safety Charity Trust. So therefore, minimal occupation is actually required for property to be rateable. You have a wonderful position of local authorities formerly arguing that minimal use was actually going to not trigger rateable occupation, to now having local authorities saying that minimal use actually does not trigger rateable occupation. So it's lovely seeing that sort of that change in the balance. Other perhaps slightly more drastic ways of dealing with rates liability. Perhaps if you're building new premises, delay the completion of those particular premises so the property doesn't go onto the list. Of course, local authorities have their own means and methods of bringing property onto a list and can serve notice, etc. in that regard. Substantial works that are going to be carried out to the property, so substantial alterations, modernisations, that should take the property out of a ratings list during the period of the works. Perhaps most drastically, demolish the property. Might be viable in certain circumstances. Constructive vandalism, where you're stripping a property back to where it becomes essentially beyond economic repair, that is also an option. However, balance that against whether or not there is an intention at some point in the future to make that property lettable again. Finally, of course, lettings to charity shops and to community amateur sports clubs. They obviously attract a different rates regime, so that may be another option. Dealing quickly with insurance, if there's a likelihood of property being unoccupied, there is equally a likelihood that there will be an impact on insurance premiums as a consequence. Increased squatter risk is never going to appeal to insurers. Increased vandalism risk is not going to appeal to insurers. Damage inside property that goes unnoticed because nobody's inside it is equally not going to appeal to them. There's no tenant to occupy, there's no tenant to repair, no tenant there to maintain a property. The risk sits with the landlord, and the insurer will expect the landlord to pay for that. So that's a basic position insurance. Insurance policies generally are long documents that contain lots of lovely legal language that I quite like getting my teeth into, but I suspect you may not. It's always very important with an insurance document to check the policy for all exclusions and conditions in respect of empty properties, because at the time that you need it most may be the time when the policy may become vitiated. So the policy may require additional security requirements where the property is vacant, may require patrols, physical measures to prevent unwanted access, may require inspections to be carried out on a periodic basis, maybe obligations to keep it in repair, make sure that nothing's going to go on fire in the property. They may require the property to be mothballed, for example, draining down systems, etc. Therefore, always check it incredibly carefully, because you don't want to lose a policy at a time when you'll most need it. Moving on to the equally thorny issue of insolvency. The first question in dealing with insolvency on unoccupied properties, or potentially unoccupied properties, is to ask, do you play hard or softball? It's all very well putting a thumbscrews on a tenant by asking people like me to write aggressive letters, and that may release a landlord's very understandable pent-up frustration, but is it counterproductive? And does it make a possible insolvency an inevitable insolvency? The alternatives would appear to be, as have been well discussed in the press, rent deferral, altering rent payment dates, waiving the rent potentially, offering to market the property whilst the tenant remains in situ, and paying rent if the tenant then agrees to vacate the property. It's all a balancing act, and it's all going to be context and fact specific. But if there is a prospect of avoiding insolvency, it is better to take a little pain in restructuring arrangements than taking a lot of pain in the event of a formal insolvency process. If it is inevitable, act quickly. Act before the tenant becomes insolvent, because you can go in, you can distrain, or whilst you still can, before it becomes the commercial recovery of arrears of rent regime, which is not dissimilar, but there are subtle differences in it. If there's a rent deposit, obviously draw down on that. In any event, see what's possible to achieve before any moratorium kicks in and the process of assets are then realised and distributed to unsecured creditors, who, of course, are unlikely to receive very much at the end of the day if the tenant is insolvent. So where the property becomes unoccupied and the tenant is insolvent, what's the position? Well, as regards liabilities, the landlord will not be liable for rates, etc., whilst the property is unoccupied during an administration or liquidation. Why? Because the lease is continuing. So the company in administration theoretically has that liability. However, the company in liquidation or administration will also not be liable if the property is unoccupied. Why? Because a rates exemption applies to them where an administrator has been appointed or the company is being wound up. That doesn't apply to receivership, by the way, and in the situation where there is a receivership, the rates liability ranks unsecured, regardless if the property is occupied or unoccupied. So what are the risks to the landlord in that situation? Well, if there's no occupation of a property, the rent is unlikely to be being paid. The moratorium also is going to apply. Now, whilst under Atlantic Computers principles, permission to forfeit is likely to be granted in those circumstances, that's very little comfort if there is no market for the property. And in any event, landlord's going to get the property back and it's going to be liable for outgoings, etc., as it is the party with the right to immediate occupation and possession. So applying to forfeit may not be the appropriate strategy in that respect. There's also a risk of the implied surrender. I've had battles with administrators on this from time to time, where the administrator says, OK, we've left a property and it's now yours, i.e. trying to create a paper chain essentially amounting to a waiver of the lease or some sort of akin to almost like a tenant forfeiture, which is a concept which doesn't exist. But nonetheless, that's what the administrator is trying to achieve. And the landlord has to be extremely careful in that position, because if it unwillingly goes back into the property, it then risks becoming liable for the property once again and risks the lease being terminated and being at an end. So you have to play the game with the insolvency practitioners on this and say, look, we are happy to access the property. It remains your property, your liability, etc., but we will access it for purposes of securing the property and for purposes of marketing, but we are not taking possession back. And that has to be very clearly documented, because you don't want to get into the fight with the insolvency practitioner saying, oh, well, we've implicitly surrendered and you've agreed to the surrender of the property. So that's a key issue. Disclaimer is a horrible issue. Disclaimer only arises in liquidation, by the way. Where a liquidator disclaims a lease, it basically says the lease has come to an end in respect of the landlord and the insolvent tenant. The property at that point reverts back to the landlord, and the landlord will become liable for rates, etc. Now, if the landlord has a claim against the tenant in the liquidation, but the reality of it is that's not going to be of much comfort to the landlord in any particular circumstances. Arguably, on disclaimer, the position that the landlord finds itself in is unfair. There's a Scottish case on this, P&O Holdings and Glasgow City Council. Now, in that particular case, the court held that there was no liability on the part of the landlord to pay rates until the landlord had physically re-entered the property. So far, so good. However, that comes under Scottish law, not English law, and the difference is there's no concept of disclaimer in Scotland. There's only a concept of intimation. And the liquidator intimated that it didn't want the property, but it wasn't actually giving the property back per se. So it's just a straightforward issue of possession. The landlord did not repossess, it did not re-enter, so therefore under normal concepts it shouldn't be liable, and the lease continues in that regard. Where else might we find some comfort? Well, perhaps in the Insolvency Act 1986 itself. Now, it's clear from the Act that disclaimer will not affect the rights of other parties, i.e. other than the tenant, except so far as necessary to release the tenant from liability. So on the disclaimer, the tenant gets the benefit of being released from its various obligations, but the landlord immediately becomes burdened with the rate's liability. Now, the lease, a strange fiction gets created where the lease still exists to allow any subtenants in occupation to continue their occupation, setting aside issues of vesting for one moment. But why cannot the lease fiction continue to prevent a landlord from becoming liable for its obligations? It's not necessary to treat the landlord as entitled to possession to give effect to the provision in the lease, i.e. to give effect to the provision in the Act, i.e. that the tenant is released from liability. So perhaps a challenge may ultimately be brought on the Insolvency Act itself, and it'd be interesting to see what the outcome of that would be. Now, that's the unoccupied situation. So comparing that to the occupied, it's quite different. Where property is actually occupied and the tenant is an administration liquidation, case of Toshuku as regards liquidation, the case of Exeter City Council and Bairstow as regards administration apply. Rents and rates are payable as an expense of the administration liquidation if a property is being used. How do we therefore ease the pain in insolvency? Well, I don't think it's always possible to fully ease the pain. However, we can look beyond the insolvency itself. Are there any guarantors that have guaranteed the tenant's occupation? Query if the tenant's in occupation, if it's a parent guarantee, if that parent's also insolvent, usually it tends to be. But if not, that's a potential mode of recovery. Is there an authorised guarantee agreement given under a new lease? Call on the former tenant. As mentioned before, you can only recover if the liability fell due within the 6 months you served notice upon the former tenant. Assuming your authorised guarantee is valid, and I can talk to you on another occasion if I'm blue in the face about the validity of authorised guarantee agreements. Assuming it is valid, go after the former tenant or the former tenant who's guaranteeing their performance of the former tenant's authorised guarantee agreement. That has to be balanced against that former tenant applying for an overriding lease. So a balance has to be made between the risk of that former tenant coming in as an overriding lessee above the current tenant. Does that outweigh the risk of just keeping the lease in the current state with the insolvent tenant in situ? Another possible option would be to draw down on a rent deposit. Now that raises an interesting issue itself. Basically, keeping it a long story short, rent deposits, if they're drafted correctly, should fall outside of the moratorium regime, and the moratorium won't apply. Subtenants, we've discussed Section 6 Law of Distress Amendment Act in 1908. Moving on to multi-let properties then, there's many issues that are relevant here. Footfall is a key one. As the effect of attendance in a shopping centre, landlord needs to think, where will the punters go? Is an empty property in a shopping centre, is it in a strategic location? What can be done to ameliorate the risks of empty property? Does there remain in situ a critical mass? For example, I used to work for British Steel and then Chorus and Tredegar in South Wales. British Steel would have been one of the biggest employers in the town at the time. Chorus became Tata, and Tata said Tata to Tredegar, further impacting on a deprived area. Now, one of the most depressing things about Tredegar, and apologies if anyone comes from there, is the concrete cast shopping centre that exists there. Very unwelcoming in a time of boom, let alone a time of prolonged downturn. The impact of empty properties in this small, unloved, windswept part of South Wales, much more greatly felt than, say, in Bluewater, where the area is more affluent. Empty properties are unlikely to have a significant effect on footfall, etc. So that's relevant. New lease rents, that's relevant in multi-let properties. Market rents, where there's empty units in centre, are much likely to be lower than those in the equivalent centre, which is fully occupied. Possibly good news for a tenant, but that tenant has to balance it off against, will it get people coming through the door of the centre? Either way, bad news for landlord. Rent review clearly will have an impact there as well, though there might be a degree of protection if the rent review is upwards only, so resist calls for the rent reviews to go up and down when leases are being negotiated. Insurance, rent, service charge. Landlord may well find that it's entered into contracts with contractors to provide services and is liable to pay for those, but if it's not getting in the money, it's coming in from service charge and insurance rent, that might be problematic in that it remains then liable to pay those charges. I'm a bit pressed for time, so I won't talk about the solutions there, but they're similar to what's before. Anticipate what the tenant's going to do, try and manage the process as best as possible. Finally, moving on to trespass. Well, the current law has given us two regimes, a civil and criminal one. Section 7 of the Criminal Law Act 77 made it an offence for a trespasser who enters premises as a trespasser and who fails to leave a premises if asked to do so by a displaced residential occupier. No such offence exists in respect of commercial property. Now, Section 144, which I'm sure you've heard about, of the catchily entitled Legal Aid Sentencing and Punishment of Offenders Act 2012, makes it an offence punishable by imprisonment or a fine where a trespasser enters a residential building knowing or ought to have known that they were a trespasser and the trespasser is living or intending to live in the residential building for any period. Essentially, what the new law covers is residential investment property and second homeowners. Section 144 does not apply to commercial property. Therefore, and rather uncivilly, trespass to commercial property is a civil and not criminal offence. This, quite often to landlords' surprise and frustration, makes it the landowner's problem to remove the trespassers. This involves obtaining a possession order or an interim possession order. The interim order can be obtained more quickly but may require undertakings, and there's issues perhaps with actually getting it enforced and police interest in it as well. So for problems of current law, the time it takes to actually get an order to get a trespasser out, potentially lengthy, potentially costly. You need to go to the county court, get a hearing date, get the order, transfer enforcement to the High Court and carry out the enforcement. I think you're hearing from Share Group or have heard from Share Group in respect to that. It's not instant, and meanwhile the the trespassers are abusing the law for their own ends and cocking a snook to the landowner. I've had to deal with many situations where a trespasser goes into occupation for a defined period. For example, for a Christmas card shop, they enter 1st of December, and by the time you get to enforce and kick them out, they've traded, they've made the money, and off they go. Not helpful. World Cup shops, similar issue there. There's also problems with trying to get a trespass matter through the High Court. I've had many fights there, and similarly, London Borough of Enfield recently had a fight there where it was human rights grounds. They thought it was a pretty appropriate forum, and the High Court said no, so we had to go and waste more time going off to the County Court to get enforced, to get their order and enforce it through there. Costs significant. Costs of either securing, obviously, the property prevented in the first place, trespass in the first place, or else getting rid of them. Court fees have to be paid, my fees have to be paid, sadly. Enforcement fees have to be paid as well. And you're not likely to get any damages from the squatters for damage that they may cause or for mean rent for a period of occupation. They are generally persons unknown. Proving title can be an issue, especially if the land's unregistered and there's no title deeds, or it can't be found. That creates some challenges. Human rights, oh, we love it. It brings up such delightful arguments used to delay or potentially to avoid the grant of an order. Now, we've seen the Occupy movement at Paternoster Square using the right to freedom of expression and assembly to prolong their stay there, or indeed the right to a home or private life is also another one that gets used. Owners of land, believe it or not, owe duties of care to trespassers. So you might be liable if they hurt themselves in your property. I have moral objections to that. Similarly, I equally have objections to the fact that there seem to be many squatters' right groups which seem to exist designed to encourage squatting, and there's organised squatting gangs which exist to look to exploit the law, much to the frustration of landowners. And I say on a personal note, I was shocked to see that the Law Society is not in favour of changing the law to protect commercial owners. And I would have to say that the Law Society certainly doesn't speak for me, and equally it does not speak for the Property Litigation Association as well in that regard. It was certainly a surprise to all of us, the submissions that they made in that respect. The unintended consequence of the current legislation, i.e. new Section 144, is that squatters will target and are targeting commercial property, as a lack of a criminal offence will allow them to play the civil system to string out their occupation for as long as possible with the attendant costs and risk consequences. How do we manage the risk? I won't talk to you about what Camelot do. I think what they do is fantastic. They'll tell you all about that, and indeed I have been telling you all about it. Other than that, effective security, relet the property as quickly as possible, deal with the police, liaise with them. If there's a genuine threat of a trespass, seek an injunction. Prevent it happening in the first place. Prevention is generally better than cure. Many of you will see notices dotted around open spaces in the city that say, penal order, if you breach this, we're going to arrest you because we've got a nice injunction out at Canary Wharf. It's got many of them around the Canary Wharf estate, for example. be proactive, prepare trespass packs so that as soon as there's a trespasser, you can bring off a shelf, claim form, particulars of claim, all the documents you need to simply fill out the blanks and off you go. Act quickly, clearly. Finally, I just want to touch very briefly on reform in respect of trespass. It would seem to me that criminalisation needs to be extended to commercial property, and it's now necessary, and it would deal with the problems we've highlighted. Mike Weatherly and Tracy Crouch MPs have been noteworthy in their promotion for extension of criminalisation to commercial properties. Reforms justified on the following few bases. The residential-commercial distinction is artificial. Either the behaviour is criminal or it is not. The current law sends mixed signals to squatters and landowners. The law should be consistent between residential and commercial property. The vast majority of MPs favoured introducing the new Section 144. Would extension of criminalisation to commercial property be so controversial so as to threaten the government obtaining a majority? Squatters' lobby groups claim that criminalisation brings vulnerable people into the criminal regime. My experience of it is generally that that is not the case. And in any event, is it really the role of commercial property owners to deal with perceived shortcomings of government housing strategy? Section 144 extended criminalisation to residential properties that were not occupied by displaced property owners. Many of the owners who now benefit from the extension own their own properties as commercial enterprises, i.e. to generate income, as opposed to actually personally residing in them. If these commercial properties are covered by Section 144, then logically it should be extended to all commercial property. Due to Section 144, squatters will now target commercial property. Squatting in commercial property should now be criminalised to create equilibrium in the law and end the scourge of squatting in commercial properties. I finish with the words of Crispin Blunt, the Under-Secretary of State for Prisons and Probation and Justice. He promoted residential criminalisation. No matter how compelling or difficult the squatter's own circumstances are claimed to be, it is wrong that legitimate occupants should be deprived of their use of the property. I remain concerned about squatting in commercial premises. We will keep the situation under review in relation to non-residential property and are not ruling out further action in the future if it is needed. I would submit that further action is now needed, and I encourage you to write to your MPs if you're concerned about the issue, to highlight your experiences and problems to them so that they can act upon it and reflect your interests. Many thanks.
Quite impressive, that much facts in 30 minutes. Usually this man charges £240 for each question asked per hour, so please could take the opportunity and ask him one for free.
You mentioned about forfeiture in a lease. Say, for example, you have a situation where the landlord gains the property back on the basis of the tenant non-payment of rent, and they gain peaceable re-entry to that property. The tenant then has 6 months to apply to court to get that property back. Is there any way around it in possibly re-letting that property during that 6 months? Is there a licence, for example?
Yes, that is possible. Indeed, at Clifford Chance, we've created letting documents that are essentially conditional upon upon any application for relief being successful. So it is possible, so it's not sterile. Also, if you have the case where the tenant has actually vacated and it's clear that they've abandoned the property, the 6 month period is equitable, so it's flexible. So in other words, is what time should the tenant have applied for relief? And in those sort of circumstances, the court will say, well, look, the tenant's cleared off. It showed no interest in the property, so the court's going to say if the tenant rocks up on 5 months and 20 days, look, you're too late, sunshine.
Also, I've got one about insolvency. So say, for example, you take the keys back on the basis of just purely holding purposes and insurance purposes. You said about also marketing it and potentially showing tenants around. Does that not constitute to or imply that there's possible surrender of the lease?
That's what you have to avoid, absolutely. That's the real risk. So it has to be absolutely clear, and what I tend to do is I enter into exchange of correspondence with the insolvency practitioner where it is confirmed that I'm only being allowed access, or my agent, client's agent's only being allowed access solely for the purposes of security and for showing people around to market the property, and that possession is not being recovered.
Okay, so if you want to do it for marketing purposes, you must clearly state that in any correspondence that you have?
To avoid any dispute arising, yes.